Hello, YouTube. I am Vince White. I am an employment attorney, and we are answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Jante Woodbury, who asked us during the EEOC process, do defense attorneys commonly refuse settlement negotiations, stating they believe the case is a summary judgment case? As a defense tactic, even if it's obvious the complaint really has sufficient evidence and valid claims. Under what instances do counsel for agency refuse negotiations? Is refusal ever used as a tactic? Will defense attorneys refuse to negotiate even though the plaintiff has a solid case? Okay, so great question. I don't know why I didn't answer it. It looks like it was asked 4 months ago, and I just ran across it and I was like, that's a great question. I can't believe I didn't help John J. Woodbury. So this happens in two circumstances. The first circumstance where they might say, listen, that case is getting dismissed at summary judgment, I'm not going to pay a dime, is a case where they really believe that, right? That, remember, defense attorneys tend to bill by the hour. So if they actually have a case where they believe they can get it dismissed, they want to bill as much as they can on that case, which going all the way to summary judgment is pretty far. That means you've gotten past the answer stage, potentially a motion to dismiss, all of the discovery, and then drafted a rather large summary judgment motion. So they've probably made somewhere between $20,000 and $100,000 defending this case at that point, depending on the firm and depending on how things went down in the case. It can be sizable, right? Probably at summary judgment, you're probably looking at most defense firms have probably billed 40K-ish, although there's certainly a big variance, as I just noted. So if they actually think they can get the case dismissed in summary judgment, they will, because that's the case out of their docket that they're going to choose to bill as much as possible and then end up looking good for getting it dismissed. On cases they're not so sure about, they're going to want to settle because they don't want to be embarrassed. If they're embarrassed, they lose a case big, they go to trial and they lose, they can lose clients pretty quickly, right? Clients are going to say, oh, that attorney's an idiot. She or he gave us bad advice and we got to stop working with this person, right? So that's the first scenario, and probably, frankly, the most common scenario where a defense attorney would refuse to settle a case. Just is what it is. Now, tied into that, they have to believe it's going to be something they can actually get dismissed in summary judgment, and the plaintiff has to be demanding enough that it makes sense to bill all that money, right? And I'll explain. So there's a lot of cases in the world that maybe aren't so great, but the plaintiff would actually take like $10,000, $15,000, $20,000. That's nuisance value in most of these cases. It's pretty hard for an employer to hire a defense attorney and defend a case for less than 10 to 20 grand. So a lot of times, defense counsel will be brought in a situation just offer that person 10 to 20 grand because the case might be junk. The case might have no value, but the employer might know or might believe that the plaintiff would just take nuisance value money. So, 10 to 20 grand. And listen, there's a lot of reasons why a case can go south, like no aspersions cast on anyone in terms of like bringing a case like that or anything like that. It's just, cases, sometimes new information comes up, sometimes things change, sometimes there's a misunderstanding that gets ironed out and it's not what you thought it was. So stuff happens and you look at a case and say, well, this is a decent settlement in this situation, right? So to get a case where defense counsel is refusing to negotiate, you need them to generally actually believe it's going to be dismissed, and for the demand to be higher than the nuisance value, right? Those two things have to be in play. Now, that's the most common reason why defense counsel would refuse to negotiate a settlement on a case. There is another scenario that I've seen a couple times, and I'm not going to give his full name, but there's a defense attorney who's a rather famous rainmaker for his defense law firm, his employment defense law firm. It's a large law firm. It's not all they do. They do other things too, but he generates a lot of the business for their employment defense group, and it's a very profitable group for this firm. And I'm not going to say what city he's based out of, but we'll call him Weber. Let's just call him Weber. And he'll hop on the phone, even though he's primarily a rainmaker. He doesn't really practice law. He's not. Let me put it this way: if you had family, you wouldn't have Weber handle the case defending your family against an employment claim, right? He's more of a sales professional, you might say, right? But sometimes with a person like that, his clients will be like, we need you to handle this specifically. And he will, because he's not the sharpest crayon in the box. And he'll get on the phone and he'll just start barking at associates like, you have no case. And it's just like, okay, dude, can you put an adult on the phone? And he's like in his like 50s. He is, in terms of temporal measurement, he is an adult. But he thinks he can just say things. Like, he once tried to tell me the law in retaliation on a case. And I was just like, yeah, so you and I both know that's not the law. Do you want me to like copy and paste the law to you? Would that help you helpful? And, you know, because he wanted to be a big, strong man defending his client, said a variety of things to me. And I sat there listening to him, bought the domain name of his name and put the law and the specific quotes and the specific case law that he was misquoting on that website, and I've left it up for years. So now when people Google his name, which I'm sure he does often, he gets to look at the law that he is and was mistaken about. Now, why was he doing that? He knew, I think he knew, that he was misquoting the law. And I don't know why he was misquoting the law. Maybe he thought his clients could hear him. Maybe they were in the background. Like, maybe he wanted to sound like a tough guy. I don't know. Or maybe he wanted to blow the case up so he could bill 6 figures plus on the case, because that case did go on for years because of his unreasonable position. And his associates, who are actual attorneys who can actually run cases and litigate them successfully, ran that case for years, knowing full well that they were at a major disadvantage under the law because he was misquoting the law. And I suspect he was doing it to just drain his clients dry. Maybe he knew this wasn't going to be a client for too long. Maybe it was a client who didn't have a lot of cases. Who knows? Maybe it was a client who didn't care about money and they just don't care about paying their attorney's fees, so he knew he could drain them dry, right? And am I saying that a defense attorney might misquote the law and fight a good case to the very end without a settlement just to bill? Yeah, I'm definitely saying that. They're not all like that. I know many who aren't. I know many wonderful, noble, talented defense counsel, but you know, not all defense attorneys are created equal. So I suspect that's another reason why defense counsel will sometimes refuse to settle a case. Maybe daddy needs a new hot tub. I don't know. Although, I mean, in context, a hot tub is not sufficient. I would say maybe daddy needs a new Tesla Cybertruck. I don't know. I mean, what does a defense attorney lust after? I don't know. $5,000 suits? Perhaps, but I mean, it's got to be more than that. I don't know. I don't know what they want. I guess they're all humans. They all want different things. So the most likely answer to your question is that attorney probably thinks they can beat your case and that you're demanding too much for nuisance value or a small settlement, so they'd rather bill the hell out of it and try to beat your case. There's also the outside chance that you have an asshat of a defense counsel who is doing something sketchy or is just stupid. But I gotta stress, most of the time it's gonna be they think they can beat your case, and they can make a lot of money doing it. So, anyways, Jonte Woodbury, I hope this is helpful. If it's not helpful, please comment down below. I will track the comments. I will try to answer your more specific questions with follow-ups. And if it was helpful, like and subscribe. Take care.